This takes us to item number 7. Ian, you ready?
Madam Chair,
You're going to tee it off?
yes, your fiduciary counsel and I and Lamont King and our outside fiduciary insurance consultant and our broker are all working together to sort of make as bulletproof as possible our current policy. So there is, currently we are in communication with our broker to make some adjustments to our current policy based upon legal advice from your fiduciary counsel and his law firm. And also we retain somebody, an expert in the field from Siegel to sort of advise us. So we are we're in the context of that. Since some of it involves negotiation on terms, I really don't want to be more specific at this
Okay.
time, but we are we're actively pursuing trying to resolve all the issues on the fiduciary insurance. And I appreciate you stepping up here. I did watch February's tape, so if you don't mind, I'll just go ahead on this a little bit, because I didn't see any changes on the actual policy. Oh, I know, but I just, I look to you for guidance and advice as the more senior attorney, not by much. However, I did look at it after February's meeting, and I did make a editorial change that does not show up as a red line in your copy due to, yes, it's TRB 254, and it's solely due to my inability to properly use track changes in Word. So if you see under subsection C, there's a full paragraph with number 1 and 2, and then there's a small paragraph. And the current language says, in consultation with the general counsel, the board will determine whether to take additional actions such as seeking recovery on behalf of CalSTRS against the fiduciaries. The prior language said the board will undertake an investigation to determine. And it's a minor thing, but just from my standpoint, imposing upon the board the duty to conduct an investigation it just seemed like it was a little bit too precise, whereas the board can just order somebody, like the general counsel, to gather information and then make a determination. So it was a very, very minor change. But again, I wanted to bring it to your attention. Sort of taking out the absolute requirement that the board conduct an investigation. I think that's sort of requiring too much ministerial work on your part, but leaving it that you still determine. The determination is the board's.
Okay.
But how they gather the information is, that's where you have staff or outside counsel or whatever you want to use.
All righty, thank you.
So there were no other proposed changes as far as I know.
Ian, did you?
No, I mean, this is good for now. I mean, you know that I've recommended seeking first dollar coverage, whether something is considered indemnifiable or non-indemnifiable. If we succeed in doing that, then, a lot of this won't be necessary.
All right. And we have that coming up for renewal sometime soon.
Yes, so that's why we are, any negotiation or any change in the current policy, the part of where our position is that it would be carried forward into the next year, which would then allow us to engage in another competitive process the following year. So because there wouldn't be enough time to really review and place new coverage. And quite frankly, since we've worked on this one for quite a while, once we get it right, I think we want to stick with it for at least until we can get into the competitive process for next year.
All righty, this is for action, second reading. Is there any further input into the policy? Entertain a motion to approve the policy then?
So moved. Second.
It's been moved and seconded to approve our board indemnification policy. All in favor say aye.
Aye.
All opposed nay. Any abstentions? We've approved that policy. Ian, Brian, and everyone, thank you very much for your work on this. Alrighty, Subrogation Authority. John and Michelle.
Good afternoon.
Good afternoon.
All right, subrogation. We have one lawyer up there and what's subrogation? So I first want to, well, it's going to relate to the previous item about money not coming in. This is to get money to come in. Next to me is Michelle Inchel. She's a staff counsel in the legal office, has done a lot of work on this, a lot of legal research, and has worked with the program area, the disability and survivor benefits area. Suzanne DeFonte is the director, and she's in the back. And if there's any specific questions from the program area, Suzanne can answer them. So I'm going to turn it over to Michelle.
The purpose of this board item is to give the board background regarding CalSTRS subrogation procedures and ask the board to take action to amend the CEO delegation. Our internal subrogation process involves a variety of business areas, and we've been establishing a framework for identifying possible subrogation cases and moving them forward to resolution. The relevant statutory scheme is laid out in the California Education Code. And the law is trying to capture the idea that because CalSTRS is going to have to pay out more benefits over the course of either the member or beneficiary's lifetime, we expect to be reimbursed by the party that caused that injury or loss. We've provided some information in the board materials regarding the statutory framework of CalSTRS subrogation rights. And a short summary of the business process. Attachment 1 contains the relevant Education Code statutes that apply. Education Code Section 24500 describes how our subrogation claim is calculated. Attachment 2 is the letter that is sent out by staff from Disability and Survivor Benefits upon notification that a third party caused the member's injuries. We recognize that the member could already have initiated litigation or possibly in settlement discussion, so we put the member on notice. Attachment 3 contains sample calculations from our external actuary, and I believe they're still here. Yes, to answer if you have more detailed questions about their calculation process. And I believe they also have done work for another plan as far as calculating subrogation claims. Attachment 4 is staff's recommended amendment to the Chief Executive Officer delegation. The proposed amendment would allow staff to file claims, intervene as a party to an already existing claim, accept payments, negotiate settlements, and contract with outside counsel for representation. We have an existing relationship with the Attorney General's office, and we anticipate continuing to use the Attorney General's office if the subrogation claim cannot be resolved by internal legal staff. As stated in the board item, if the board would like, we could provide, we could work with benefits and services staff to provide an annual update on subrogation accomplishments before the Benefits and Services Committee, and we can work with Peggy possibly to do that. And of course, any claim that was resulting in actual litigation, most likely in a superior court somewhere, we would provide those updates in the litigation report that you receive. With that, staff recommends that the board adopt the proposed revisions to the delegation of authority to the Chief Executive Officer, granting the Chief Executive Officer the authority to take action to pursue and resolve subrogation claims. And I'm available to answer any questions that you might have.
Anna?
I think delegation makes sense. I think regular updates to the board would be quite helpful and important.
And we'd look at the delegation authority on a regular basis, so the ability to revisit this would happen when we do that. When we take a look at the delegation authority. All right, is this the first time we've done this? I mean, are we just now being allowed to do it, or if we just never taken advantage of a law that?
If I can, we did back in '94, I think.
1989.
1989, the then current board kind of skipped ahead and said, this is what we're going to use to collect on these claims. And they basically said, approved using the Attorney General services to collect on the claims. The statute, the current statute, though, requires a individual board resolution to pursue an individual claim. And we feel like back in 1989, they didn't cross the T and dot the I And, you know, it's our recommendation that each individual subrogation claim not come to this board for prior resolution and approval. This is sort of, and we'd be happy, Michelle and John are happy to explain how, on subrogation claims, but this is pretty much a bread and butter kind of legal procedure that really is, I personally don't think it's something that you would want to be spending your time on, recognizing that we will pursue every last dollar on the table if we can. So that's, I'm sorry I interrupted Michelle, but that's kind of the background. We have been operating under board approval, but it's not exact enough for our taste, so that's why we're here.
And just to add, that 1989 resolution was found very recently, or else we would have included it in the board materials, but we want the delegation to be, you know, whether or not there were one-off resolutions in the 80s and 90s, we want the CEO delegation to have, to be the centralized place where we, and especially if those resolutions in the 80s or 90s were not properly written or as thorough as we'd like to be now.
But we don't know, we weren't there.
We'll be more proper at least now. Alrighty, Rich?
This is a new one to me too. Does this work? This process, do we collect, I mean, I just,
Yeah, I'm sorry, John and Michelle especially can tell you, because she's been following the 1989 resolution and collecting.
Well, I've only been doing it for a few months, and you know, the statutory scheme is strong, and it evidences the legislature's intent for CalSTRS to have a cause of action to be reimbursed by the harmful actions of a third party.
I mean, how much do we collect? Because
Suzanne
it is.
DeFonte can speak to a specific case.
Just
I-
roughly,
yeah.
I don't,
Anywhere from $250,000 probably down to about $30,000, depending on the claim.
but what's a total? I understand what one claim is. Do we have 100 claims a year? Do we have 5 claims a year? Do we have?
I've only been doing this for the past few months. I currently have around 7 cases where the dollar values, you know, range from anywhere from $50,000 to, as you see in the board item, over $400,000, and they are all in active negotiation and resolution moving
And we have done a
forwards.
cost-benefit analysis on this? I mean, right, if we are collecting $150,000 a year and we are spending $250,000 a year to collect it?
And let me address that, Rich, because as a reformed litigator,
Yes.
this is kind of something that we do on a regular basis. It's sort of, we have a claim, it's almost as though we're a medical provider, if you will. So there's an accident, someone is hurt, that person happens unfortunately to be one of our members, that member is disabled, we pay out a disability allowance. At the same time, that member and the council pursue a lawsuit against the person who caused the injury. When there's usually what happens is when they want to settle these cases, because most cases settle, they want to eliminate all the claimants at the same time. So there's a pot of money on the table. And so we want to get in there and press our particular reimbursement claim. Basically, it's a reimbursement claim. We get to get money from the tortfeasor, the person who caused the injury, to repay the system for the disability benefits that we are paying out because of that person's bad action.
And is it just disability benefits, not like retirement benefits?
Well, yeah, go ahead, Peggy, I'm sorry.
So I would say we probably haven't been pursuing these claims as aggressively as we could, and part of what we've struggled with is this delegation issue. So, you know, we're well prepared to more aggressively manage this and do a more rigorous review. When someone submits a disability application, we do ask on the application form itself if your injury was caused by a third party. If it was caused by their employer, then we'd have no subrogation rights, because the employer is a different, and it could also extend, I was getting there.
Okay.
It can also extend to survivor benefits if we're paying additional survivor benefits because of the actions of a third party. So the the system, that's why we have the actuary involved, does an assessment of what is the difference between what that person would have earned on a service retirement and what the additional cost to the system is to pay the disability. And that's the amount we go after in subrogation, because we assume that we already have a payout responsibility for any given member based on the contributions and received to date and the service credit earned to date.
Okay, I'm with you. I'm trying to see how wide it goes. And we now have hired not only lawyers, but actuaries. So the question is, do we, I understand that. Are we really getting our money's worth out of the amount of
I
investment?
didn't get a chance to finish
Oh,
answering your
okay.
question, Rich. So very often, these cases are resolved by the lawyers getting on the phone with the plaintiff and defense counsel and saying, okay, you want to settle this, here's what we are claiming. We start off with 100 cents on the dollar, and we do our very best to, and many of these things are resolved in negotiation. The piece that we need is we need from the sort of what our value is, what's due and owing to us, and that's where we get that from the wise
Make sure we're
actuaries.
coming out ahead with that process.
Rick, before, this is amplifying, I can see, but it's just good to point out, this is just day in and day out practice of every insurance company in the United States. Subrogation is part of claims administration, so it may sound a little different in our venue here, but it's part of the insurance world and just part of making sure you get adequate recovery. And that's why you always have to answer that little question when you go in for medical care, because the insurance companies want to make sure they get every dollar back. So that's all we're doing here.
As far as the actuarial services, there's no additional cost. It's part of the regular routine service, so they don't charge us anything additional for it.
It's you.
I would say too, that would be part of the analysis we would do to see whether to pursue it. What this would do would just give us the authority to do it in-house instead of coming to you every single time we had one to get approval.
And for what it's worth, from wearing my other hat in the Medi-Cal program, the third-party liability and third-party recovery is something that we do on a pretty regular basis. Medi-Cal pays for the claim, and then we seek compensation from third party, and it's generally a proposition that pays for itself.
And I know there are some staff from the Attorney General's office who have worked with various state agencies in representing, assisting, and their rates are far lower than in the private sector, and they represent a variety of state agencies at that reduced rate.
Well, and we would propose that we add this as a section to the annual accomplishments report that we submit to you that would give you that analysis, and that's where you would see it. The number of cases, the dollar value, the cost benefit analysis associated with it. So, you know, we're anticipating a regular report back to you.
Sharon?
I just move approval.
All right, it's been moved. It's been moved and seconded. Is there any further discussion? It's been moved and seconded. Is there any further discussion? All in favor say aye. Aye. All opposed nay. Jack, go forth and subrogate, I guess, would be the disposition of that item. All righty. Moving on to Julia, come on up. The overview of the DC program.
We give you a regular report on the activity associated with our defined contribution programs, but when Julia and Ed and I talked a little bit about where we are with the program, we realized that not all of you really knew all the parts of this, their history of this, and what we'd like to do, and so this isn't just a little abstract educational item today. I want you to feel comfortable enough with this program. As we look into it, we believe there's need for some additional policies around this program, around looking at how we structure the investment lineup, the decisions around the investments, the decisions around delegation. So today is just kind of looking at the building blocks of the program and making sure you know what the moving parts are of the program. And then Julia, Ed will come back with our attorneys looking at policies, and we'll move through this program then operationally to see where it needs some strengthening around policy development. But today's, as I said, just education on making sure you know what's what and how it came about.
Good afternoon.
You go.
Okay. Well, the purpose of this information item is to acquaint you with the history of the Supplemental Savings Program. And I start with this slide because earlier today you've already heard about the traditional defined benefit and the cash balance and defined benefit supplement. We represent the third portion of the hybrid model, which is the defined contribution and the Pension 2 program. The current K through 12 defined contribution marketplace, it includes two types of plans that are available to our educators, and that is the 403B and the 457B plan. Employees have an opportunity to participate in both on a tax-deferred basis. In 1994, the California Teachers Association and the CalSTRS board approved, they co-sponsored a bill authorizing the creation of the 403B program. The 403B program started with three investment options: a money market fund, the S&P 500, and an international equity fund. Participation was low, as the full report indicates, and the program didn't meet the 2% of active membership required to continue the program. However, the board authorized the continuation of the program as a low-cost alternative to the annuity products that were available. Fast forward to 2001, changes to the federal law allowed employees to contribute to both the 403B and the 457 plan under separate annual contribution limits rather than the single contribution limit that existed, and CalSTRS introduced the 457 program in 2007. This new comprehensive program is called Pension 2, and the name was intended to reflect the relationship between the employee's defined benefit, which was their primary retirement benefit, Pension 1, and the supplemental savings plan, Pension 2, was designed to represent the second portion of their pension. During the transition to Pension 2, the board was involved in approving the initial lineup, which consisted of 14 core funds and the 15 Easy Choice portfolios, which is a combination of a risk and target date funds. In 2009, staff created the Pension 2 Investment Committee, which consists of program staff from DCS, the investment staff, and CalSTRS financial consultant for the Pension 2 program. The primary responsibility of the committee is to select and monitor the underlying investment options and make necessary changes and adjustments. One of the first tasks that the committee did was to evaluate an expansion of the fund lineup. We did this to address industry trends as well as requests being made on behalf of participants and the investment advisors who recommend the Pension 2 program to their clients. The fund lineup was increased from 14 to 22 investment options. The committee also created the investment policy statement, which is designed to establish guidelines for operating the program and to identify how decisions are made on behalf of the program. Okay. The Pension 2 program has experienced steady growth, averaging 10% annually. Currently, the 403B had approximately $168 million in assets as of December 2007, and the 457, which is by adoption only, didn't actually gain participants until 2008 with the first adoption. So the next couple of slides are here to show you the growth of each of the programs from 2007 to current. And as you can see, our participation has nearly doubled since 2007 from 4,235 to the 7,200 as of the end of 2012. The assets have grown equally as well. They have basically doubled since 2007 from 176 million to the current 382 million last quarter. The 457 program, again, this is the program that must be adopted by each school district, and which is a much slower growth process. It started in 2008 with our first adoptions, and we had 28 participants, and now we have 333. The assets in the 457 program, of course, when you begin with zero, it's going to grow quite rapidly. So in 2009, we had a little over 300,000 in the program, and it's increased to over 10 million today. Staff can, I want to actually acknowledge staff that have been very helpful in getting it to that huge jump from 2011 through 2012. And what this involves is a lot of rollovers, namely staff John Schiffler was involved in that and a previous employee, Patrick Bivens. And they did an incredible job of securing several sole provider adoptions, which brought over quite a few contributions. So good job to those staff. So future changes, it's important to note that CalSTRS is the fiduciary for each of the programs that are administered. However, it's important to also note that we do have safeguards in place to protect CalSTRS in various situations. In the coming months, we'll be coming to you and presenting a number of actions to consider relating to the defined contribution programs that we offer. And the purpose in explaining this history is to help provide you with a general sense of where the program has been, where it's evolved from, and a general sense of where it's going and the changes that are going to be necessary to operate it, for operation and success of the program. And the first item under consideration is coming up, and that's item 12D, and that is the non-competitive bid, which allows CalSTRS to continue with its current record-keeping contract through the procurement process. Another aspect of administration requires a review of the delegation of authority, and this is for decisions that are made on behalf of the Pension II program. Again, these are introductory items as for things that'll be coming. Excuse me. The next program that I'll be presenting to you on is the CalSTRS 403B Comply. It's a compliance and administration program. 403B Comply was created after it was evident that the IRS was going to substantially increase the administrative responsibilities for school employers who offer the 403B plans. And CalSTRS was asked to come in and help with the administration of these programs by several schools. At that time, staff presented to the board information regarding the development of the Comply program, including funding for the marketing and administration of the program, which the board approved. When we first started out with the compliance program, a company was initially hired to implement the compliance and administration program. This company basically underestimated the cost of providing compliance, as did many others in the industry, the true cost of providing compliance, and they didn't really have a good understanding of the K through 12 marketplace in California, which is different. The program didn't have sufficient policies and procedures in place to competitively bid for these. We do have to compete with everyone else for the business, and they were unable to fill the terms of their agreement. So a second RFI was issued, and another company was hired that was capable to do this. However, during that time that we were out of the market, we missed out on some key opportunities with districts, so we weren't able to secure as much as we had anticipated. And this left the program out of the marketplace during the most critical time. But despite these setbacks, the program has actually been very successful, and all revenue generated net of expenses is applied towards a repayment of the startup cost. So under the current structure, the interest on the payment of the program startup cost, it has presented us with a challenge in calculating a sound repayment schedule. So again, this is historical because we will be coming to you later with with additional information on this repayment process. As for the path forward, in the coming months, again, we'll present the following items to you. Approval of the non-competitive bid, which is in item 12D, the delegation of authority for oversight of the Pension II Advisory Council, repayment of the Comply program startup cost, and then in the future, approval of the Pension II record-keeping contract, which we hope will offer some enhanced participant and employer services to the program. And that concludes my presentation. Are there any questions?
Anyone? Thank you, Julia, for the background. We look forward to working through that process with you, so thank you very much. Alrighty, moving right along. We have Jack's report.
I wasn't going to go back through it. It's pretty lengthy what you have there. We tried to provide you a good summary of the legislative hearing. I wanted to thank Dana, though, particularly as our chair, for kicking off our testimony at the legislative hearing. I think what we all found of interest was throughout all the varieties of parties that testified at the legislative hearing, whether it's us or the stakeholder organizations or the legislative analyst's office and others, there really was a convergence of perspective and quite a strong tone to the hearing, particularly around the issue you talked about a lot, which was the importance of a 30-year horizon. I think hearing that out of independent voices changed the temperature a bit in the room and added a sense of urgency to it when clearly the LAO said the importance of acting soon on the issue. So that was valuable to all of us. So again, if anyone has any questions for Dana or Ed, who were the primary testifiers that day, we're here for that. The only thing I want to mention, not in the report, really is what we mentioned by email to you, but I wanted to acknowledge it today publicly and also for the audience of the significant change we've had in our executive leadership of CalSTRS. As you look at our strategic plan that we worked with you last year, we absolutely have some weighty issues to tackle, particularly around our pension administration system. As we've gotten through the financial system and business direct, now we're opening our arms to working on a longer, more complex project. But we also talked about succession as those changes and aging that goes on in CalSTRS, and we need to obviously watch for that new source of leadership. So we have two big changes in the organization. One is Chris Ford has been retired now for some time, and we left her position vacant, and then we restructured the position as a chief operating officer. And I couldn't be more pleased that Cassandra Licknock, who you know well from being our human resource executive, has been selected for that. She barely waited 60 minutes and started moving things around and changing the organization and solving problems that had been lingering. So, I think that's why Cassandra really is so well suited for this. She really has a go-to perspective, and we want to get those things that fall in the siloed boundaries of an organization resolved so that they don't linger. And I think she's going to add a lot to making sure the momentum on the strategic plan, because she was always our monitor of that, but now she's in her formal role as COO. I think we can make sure that the execution of these things stays even better. The second is a most critical position, and that is the newly created position who is over Business Renew, that for the next 5+ years here will be diligently overseeing the replacement of our pension administration system. And Chris Cayetti is our new executive in charge of Business Renew. And Chris very successfully has run our project management office over the recent years. So this is just that similar kind of function with a lot more weight to it and a lot more challenge. So, I have to say, the vast majority of the CalSTRS organization falls under Cassandra's span of control. So there's a lot of weight in that assignment, and the vast weight of our project that will speak to our future success will be under Chris's arms. So both of them really will be really driving the organization's plan quite heavily. So you'll see a lot of them going forward. So that's all I have.
Super, congratulations to
Yeah.
both of you. Alrighty, thanks, Jack. Our next item is the Business Renew Oversight Assessment. So Chris, come on up, and Cream.
Anything you want to say first? No? Okay. Well, good afternoon, everyone.
Good afternoon.
I'm here to present Grant Thornton's regular independent oversight report of the Business Renew projects. This time we'll be reporting on the normal 3 projects, CALM, the Pension Solution, and the Data Prep project. Starting next month, we're going to be reporting on an additional project called Enterprise Information Management. We just started performing oversight on that project in the past month. This month will be the first report. We're going to be delivering to CalSTRS on that project, and so the next time we get together, I'll be including that in my comments. So let's start with CALM. So we've retained the Yellow Plus rating that we've had on CALM. The The reason for that is not so much related to the release 1 functionality that's now in production, although the system's had a few performance issues that the team is addressing. Generally, it's been pretty stable in production. The challenge that the project has right now is around the schedule for release 1.5, which, if you remember, was the additional functionality that couldn't be completed at the same timeline as release 1. Most of that functionality is not time sensitive, but there are some elements of it that are required in order to support the year-end close process. So those pieces of functionality have to be completed before year-end close processes are executed. And they're somewhat behind schedule at this point. The project team is reprioritizing activities and also adding additional resources to address this, to make sure that these items are completed in time. But as you can imagine, this will be sort of a major focus of our oversight in the next couple of months. CALM Release 2 planning has begun. Release 2 is the cost accounting functionality, so the planning for that part of the project has just begun in earnest, and we'll also be monitoring that over the next month or two as the Release 2 activities begin to gear up. Any questions on CALM?
Terry?
You use the term stabilization 3 times on that slide. Would you define it, please?
So that's really taking the system as it's gone live into what you might call sort of a normal operational process. So when the system goes live, there's always some sort of teething troubles, and people have to get used to using the system. So there can be like productivity delays or security issues. So what you generally see is a jump in the number of service tickets that come out from the system, either people not sure how to use the system, some minor bugs with the system, or not being able to get access to the functionality. And that's what the project team has experienced. And they're now working through that backlog, if you like, over time, to the point where you can consider it sort of a steady state, where the system is operating pretty much as intended, and the level of either help desk requests or trouble tickets is what you would consider sort of a normal state. Does that answer the question?
All right, that's fine, thanks.
Okay.
Paul?
Yeah, sort of the same question, because you said that release 1 is the green, yellow is not because of release 1. So if you were to assign a color to just release 1, how is that doing?
I would put it at green at the moment. I mean, there is still the concern we've had around the release 1 activities for a while has been the documentation of the support processes. And that's still something that the project team is working on completing. The actual software functionality, we don't have any significant concerns about. And the challenge for the project around release 1 right now is really getting the support organization up and running and fully documented in such a fashion that it's addressing all of the user requests for support as fast as they're coming in. And that's generally what's happening right now. The trouble tickets are being cleared as fast as they're being raised. There are still some early tickets that have yet to be resolved, and so they're trying to clear out some of that backlog. But that part of it is pretty much in a stable situation right now. It's a matter of making sure that they have the documentation to go along with it, so the processes are fully documented.
Thank you.